I wanted to give a brief intro into the type of people that we'd like to see in our mental health court, because it's not necessarily who people expect us to take.
At this month's local Public Safety Coordinating Council meeting, Circuit Court Judge Cromwell gave an update on the current state of Jackson County's mental health court, as well as active aid and assist docket numbers.
It is a big meeting today. We're going to hear about the judge's approach towards mental health services and responses. Well, Your Honor, very lucky to have you here, so I'm going to invite Judge Cromwell up to speak as our first agenda item.
For the first 6 months of 2021, we've really started to kind of rebuild our mental health court team. So first I'm going to go into the mental health court. And because we've got obviously a new judge took over in January, myself, and then we also have a new probation officer on the team. We have a new liaison from Jackson County Mental Health and a new liaison from Medford Police Department. And so we've also added a few team members onto there to really kind of keep us accountable and so that we're actually consulting with the people who that we're assisting as well. And so that includes a member from NAMI, who's also a veteran, and then we also have a certified recovery mentor, or a CRM, from the ARC, who has not only lived experience with mental illness, but also was in the criminal justice system and actually in prison in the past in California. We've had consistent referrals this year for our mental health court, and we're close to our cap of 20 participants. Currently, we have 2 pending referrals that haven't been staffed yet. We have 18 participants in, and there's 1 additional that's been on abscond status for now a couple of years. So currently 18 participants. So we've had 9 graduations within the past year. We have 2 more coming up in the month of August, and so it's been actually very positive. I wanted to give a brief intro into the type of people that we'd like to see in our mental health court, because it's not necessarily who people expect us to take. We oftentimes get referrals for people who have just, kind of a one-off incident where they have suffered maybe a long time or have been medicated and appropriately addressing mental health concerns, and then for some reason go off meds and then have a psychotic episode. Oftentimes those folks do not have criminal histories, and this is not the participant that we actually want to see in mental health court. Even though we'd like to see those types of people get some type of reduced sentencing or guilty except for insanity type of situations, depending on the seriousness of the case. And the DA's office has been really wonderful about dealing with those types of individuals. But the people that we want to see in mental health court are high utilizers of the systems, whether it be the hospital system, the criminal justice system, the people that are, quite frankly, really difficult for our community to deal with on a regular basis. We recently increased our program length from 12 months to 18 months. And the reason we did that is we really wanted to see longer recovery or lengthier monitored recovery before people were going back out on their own without this team surrounding them. So the reason is mental health recovery, substance abuse recovery is not a linear process, and for different people it goes different ways. And so again, similar to what I just said, is we want, if somebody is going to relapse, if somebody is going to have crisis, we want that to happen while they're in mental health court so that we can work on those tools. So on our aid and assist docket, Judge Mejia and myself rotate every other Tuesday afternoon. So we have a dedicated Tuesday afternoon docket for aid and assist. And on April 1st, we began we're probably the 3rd or 4th county in the state to begin a rapid aid and assist process for criminal defendants who are lodged in jail that have been determined that they are unable to aid and assist their attorney in their own defense due to a qualifying mental health disorder. So they're unable to even resolve their case either through trial, through a plea, or through whatever motion work. So we've had the dedicated docket, aid and assist docket on Tuesdays for a couple of years now, but the new edition is really intended to prevent people from languishing in jail needlessly while their attorney is, first of all, recognizing the issue when they go in to see them, then trying to get funding from OPDS to get an evaluator on board, locating that evaluator, scheduling that evaluator, and then waiting for a report. And before our rapid aid and assist docket, probably one of the more extreme cases, but it was about 6 months between going into the jail and recognizing that there was an issue to the date that we got the report. And that's ridiculous, not only for our jail capacity, but also for somebody languishing from mental health issues and sitting in a solitary confinement. So with the new docket, we're working with Dr. Orphan with Lithia Forensics, who he volunteered to do our our rapid aid and assist docket. And basically what it is that he has time slots kind of reserved up front for us so that if once he gets a referral, he can be in, and usually he does video because he's located out of Portland, but he'll do video visits generally and evaluations by video. So he can get in there before he actually receives funding from OPDS. So the defense attorney will apply for funding, just let him know that they've applied, and then he goes in there before he actually gets that funding because he works with them regularly and kind of knows that he'll be reimbursed. So that cuts down significantly on the wait time. And he and his team are getting reports done between referral to actual report in hand has been about 6 days on average. So it's really amazing. After that point, the person is required by law to then get a community restoration evaluation, which basically can this person be safely restored in the community by taking legal classes, ongoing meds, ongoing treatment, or is this person dangerous enough that they have to go up to the state hospital? So that community restoration evaluation is the next piece. And that has to be done within 10 judicial days if they're lodged. As of today, we have 43 defendants so far. This is 2021 numbers. 43 defendants with 104 aid and assist cases that are pending. About 79% of those folks were placed at Oregon State Hospital or are waiting to go up, and 21% of those are on community restoration. Similarly, about 20% of those defendants, their most serious charge is a misdemeanor. 80% of those defendants, their most serious charge is a felony. That's what we want to see as far as majority felony cases. And as of this year, we've had 271 aid and assist hearings, and that could be a number of different things. That could be the initial finding that they're unable to aid and assist. That could be a 9B hearing, which is when the state hospital says, hey, they're up here, they're not restored yet, but they're not dangerous, so you got to take them back in your community. Those types of hearings. It could be 7-day review hearings, which when these people are sent up to the state hospital in 2 to 3 weeks, and it's supposed to be 7 days, we have to meet with them every 7 days to make sure that there's no other alternative means of handling the matter. Able findings and never able findings. So meaning somebody comes back from the state hospital, they're found able, we proceed forward with the case, or they come back from the state hospital and their mental health status is so chronic as not likely to change, and then they're found unable and the case dismissed. So 271 between all those types of hearings. We're 6th in the state right now for aid and assist cases, which actually is probably where we should be. We've been up at 2nd, right behind Multnomah County, which for our population was not great. Here's where this comes into what you were saying, is the reason why I think we're now down to 6 is that the DA's office has been cautious about not necessarily issuing every single criminal trespass and disorderly conduct case. Here's why this matters, it's not a good solution, but when you're facing a criminal trespass in second degree, you're looking at 30 days maximum jail sentence. So
Which typically you don't serve. You serve 1 day on average.
we serve 1 day, but we're keeping people on for the aid and assist because they're not able to aid and assist, and so we'll maybe put in no matrix because they're just too disorganized to release. Then you get this rapid aid and assist process plus the community restoration process. You're looking at about 2 to 3 weeks, plus 2 to 3 weeks to get up to the state hospital. They've served their sentence, they get released. For the people that are on disorderly conduct in the second degree, maximum sentence is 6 months. So by the time all this happens, they wait to go up to the state hospital, they get up there, they're not going to be restored within the time period they have left. So there's 0 point, we're just wasting, I think it's $1,200 a day up there to send somebody back not restored and just get released anyway. So that's why the misdemeanor cases, lower level misdemeanor cases, don't make sense. It makes sense for A misdemeanors and above because they're facing a year. That's really all I had. I hope I didn't go too long, but does anybody have any questions, any other questions about aid and assist? Okay, so I'm gonna go and do my prep for my mental health docket at 1:30, so I will be
Your Honor,
back.
thank you so much
Thank
for presenting today.
Absolutely,
Yeah, really
you bet.
appreciate it.